Cleveland Board of Education versus Joe Carroll LaFleur.
In 1970, Joe Carroll LaFleur, a teacher at Patrick Henry Junior High School in Cleveland, became pregnant and was forced to discontinue her duties on March 12, 1971.
A school board policy required all pregnant teachers to take mandatory unpaid maternity leave 5 months before the due date of the child. The board also ruled that a teacher could not return from maternity leave until 1. The next school semester began, 2. The teacher obtained a certificate from her physician showing good medical health, and 3. The newborn child was 3 months old.
Miss LaFleur and another teacher from the same school, Ann Nelson, filed separate suits in the district court in the Northern District of Ohio, and then were combined together and taken to district court. They sued the Cleveland Board of Education, alleging that the school violated their rights to due process and equal protection under the 14th Amendment.
The court said that the policies were in fact constitutional. After this decision, the pair filed for an appeal, and it was accepted. A divided panel of the United States Court of Appeals, 6th Circuit, reversed, concluding that the mandatory leave policy violated the 14th Amendment's Equal Protection Clause.
At the same time, Susan Cohen, a teacher at Midlothian High School in Chesterfield County, Virginia, was going through the same thing. Cohen notified the Chesterfield School Board that she was pregnant on November 2, 1970. The board's rule required pregnant teachers to go on maternity leave at the end of their 5th month, but allowed for reemployment the next school year upon submission of a medical certificate from the teacher's physician.
Cohen's doctor believed that she was fit to continue working, but the school board denied Cohen's request for an extension. Cohen challenged the constitutionality of Chesterfield County's rule in district court, which held the regulation violated the Equal Protection Clause. The United States Court of Appeals, 4th Circuit, affirmed, but on rehearing en banc, the court upheld the constitutionality of the regulation. Represented by Jane Picker, the case made its way to the U.S. Supreme Court, where Susan Cohen joined Miss LaFleur and Miss Nelson. The Supreme Court ruled in the teachers' favor and found that the board violated their right to due process. They said filling out a form explaining their condition in advance was sufficient alone to save continuity in teaching.
In the opinion of the court, Justice Stewart went on to explain, "This court has long recognized that freedom of personal choice in matters of both marriage and family life is one of the liberties protected by the Due Process Clause. By acting to penalize the pregnant teacher for deciding to bear a child, overly restrictive maternity leave regulations can constitute a heavy burden on the exercise of these protected freedoms. Public school maternity leave rules directly affect one of the basic civil rights of man. The Due Process Clause of the 14th Amendment requires that such rules must not needlessly, arbitrarily, or capriciously impinge upon this vital area of a teacher's constitutional liberty."
Justice William Rehnquist, joined by Chief Justice Warren Burger, dissented. He argued that while the school board's rules may have been arbitrary in particular cases, this was not enough to show that the rules themselves were unconstitutional. He noted that both parties conceded that the probability of physical impairment increased as the pregnancy advanced, and suggested that the line drawn by the boards was not irrational.
The court's opinion on this case has had an important impact on society both then and now. In 1919, 86% of teachers were women. This stayed relatively the same throughout the Depression, the war, and up to the case. Yet the prejudice against women was ever present. In 1948, 43% of schools did not have maternity leave, and the rest had compulsory maternity leave. Compulsory maternity leave is unpaid forced maternity leave, which Miss Nelson, Miss LaFleur, and Miss Cohen were fighting against.
In my opinion, women should be able to make their own decision. Roughly 30% of women teachers are in the childbearing age range. It would be insane to force out all of these women who are perfectly capable of teaching. For example, Mrs. Slattery was teaching until the week before she was due. I have to admit that some women are crazy when they're pregnant, but I also think that they will have the right judgment to leave their job when they can't handle it. It makes me happy to see women fighting for their rights.
In my opinion, women should be able to make their own decision as well. There are women that do much more complex, much more hard jobs. Not saying that teaching is not a hard job. And they are not forced to go on maternity leave, so why should a woman teaching be forced to be put on maternity leave?